A very warm welcome to all. Today, I, Reeya Khanna, a legal intern under Lexis and Company, am here to give my presentation on the case Maneka Gandhi versus Union of India, 1978 AIR 597. The petitioner of this case is Maneka Gandhi and the respondent is the Union of India. The judgment was delivered on 25th January 1978, which was led by the bench Hamidullah Beg, the Chief Justice of India then, Justice V.Y. Chandrachud, Justice P.N. Bhagwati, Justice V.R. Krishna Iyer, Justice N.L. Untwali, Justice S.M. Fazal Ali, and Justice P.S. Kaisalam. In this case, the Supreme Court in Satwant Singh held that right to travel abroad is well within the ambit of Article 21. Therefore, to combat the above laid down law, the Parliament enacted the Passport Act 1967. Passport Act 1967 empowers the authorities to impound the passport of certain individuals if such action is necessary in the interest of sovereignty and integrity of India and the security of India, friendly relations of India with any foreign country or general public. The reasons of such impoundment are also to be communicated to the affected party. However, in the interest of general public, these reasons can be withheld. In the immediate case, the authorities on 4 July 1977 issued a notice of impoundment of the passport of petitioner who was a known journalist, citing reason as in the interest of general public. As soon as the petitioner got the notice of such impound, she reverted back to the authorities asking for specific detailed reasons. The authorities, however, answered that the reasons are not to be specified in the interest of general public. Therefore, the petitioner approached the Supreme Court under Article 32 of Constitution of India for the enforcement of fundamental rights mentioned under Article 14 against the arbitrary action of the authorities. The petitioner was further petition was further amended and enforced of Article 21, that is protection of life and personal liberty, Article 19 clause 1a, that is right to freedom of speech, and Article 19 clause 1g, that is right to freedom of movement. Among the major reasons contended for filing of such petition, the petitioner contended that the impugned order is void as it took away the petitioner's right to be given a fair hearing to present her defense. This case directly brought into question the legality and the validity of A.K. Gopalan versus State of Madras. In that case, it was argued by the petitioner that whether the validity of any law shall be decided by the fact that it is a procedure established by law, or the law along with being established by law shall also conform to principles of natural justice. The main debate was around the scope of the word procedure established by law, on the point that can such procedure be arbitrary or unreasonable, or should it always be just, reasonable, and fair. The majority bench, however, rejecting all the arguments of the petitioner, held that the word law under Article 21 does not necessarily be in conformity with the principles of natural justice. But it was Justice Fazal Ali's opinion in the case that paved way for a liberal approach of interpretation of Article 21. Justice Fazal Ali dissented with the majority by holding that right to life under Article 21 does constitute principles of natural justice, and the courts should check that any procedure established by law does not suffer with the problem of unreasonableness and arbitrariness. The spirit of Justice Fazal Ali's argument was that the procedure should be just, fair, and reasonable. The court in Maneka Gandhi adopted the dissenting view of Justice Fazal Ali in A.K. Gopalan versus State of Madras. Therefore, the court held that while the procedure established by law should be reasonable, just, and fair, it shall be free from any unreasonableness and arbitrariness. Now let's talk about the main issues highlighted in this case. Number one, is there any nexus between the provisions mentioned under Article 14, Article 19, and Article 21 of the Constitution of India? Number two, what is the scope of the word procedure established by law? Number three, whether right to travel abroad resides in Article 21. And number four, whether a legislative law that takes away right to life is reasonable or not. Now, let's understand the judgment. The landmark judgment came on 25th January 1978 and changed the landscape of Constitution of India. This judgment expanded the scope of Article 21 exponentially, and this judgment truly and really made India a welfare state, as promised in the preamble. The 7-judge bench gave a unanimous decision, except some judges concurring on some points. There were 7 separate opinions in which the majority opinion was written by Justice Bhagwati for himself, Justice Untwalia and Justice Fazal Ali, while Justice Chandrachud, Justice Iyer and Justice Beg wrote separate but concurring opinions. The major findings of the court were: the court, while delivering its landmark judgment, changed the landscape of the Constitution by holding that though the phrase used in Article 21 is the procedure established by law, instead of due process of law, however, the procedure must be free from arbitrariness and irrationality. Even though the constitution makers must be respected, but they never intended to plant such a self-destructive bomb in the heart of the constitution. They were never of the mind that the procedure need not necessarily be reasonable, just, and fair. They drafted this constitution for the protection of people of India, and such interpretation of Article 21 will be counterproductive to the protection offered by the constitution. The court overruled Gopalan by stating that there is a unique relationship between the provisions of Article 14, Article 19, and 21, and every law must pass the test of said provisions. Further, the court held that the scope of personal liberty is not construed in a narrow and stricter sense. The Maneka Gandhi judgment was a balanced judgment, and it is one of the best judgments of Indian Supreme Court has ever given. The judgment's greatest feature was the interlinking the establishment between the provisions of Article 14, 19, and 21. And by the virtue of this link, the court made these provisions inseparable and a single entity. Thank you so much.